Okay, good morning, everybody. Welcome. My name is Tom Pico, and I'm the president and CEO for the Penobscot Bay Regional Chamber of Commerce. We welcome you to our fourth and final Tourism Tuesday. So we're looking forward to hearing from Rebecca this morning, and we'll get to her in just a moment. But before we dive into today's topic, a couple of other quick items to share with you. As we always do, I want to thank our premium members for their support of the Chamber. Our premium members of the Chamber are LCI, Machias Savings Bank, Eaton Peabody, of course, and Ballou and Associates. So we thank them all for their additional investment in the Chamber. You have probably, if you've been on these before, you've heard me talk about our Jewel and our Jewel Addendum, but just to make sure you're aware, we have our continuing to use our 2020 Jewel Guide, and we've published an addendum to go together with it with a nice little purple sticker on the front so that everybody knows it's there. So we have copies of those now, and love to get those out into your business. Just give us a call and we'd be happy to get you a supply of those. I hope you had a chance last Wednesday or since then to view our virtual awards gala, which was great fun, and we were excited to share all of the awards with you, including our Community Person of the Year. That's still living on our YouTube channel, so if you haven't had a chance to see it, I'd encourage you to go and check that out. We want to thank First National Bank for sponsoring our Tourism Tuesday series, and we have a couple of representatives from First National Bank. I'm going to turn it over to Nicole Quinn first, and Nicole, you can give a welcome and then introduce Monique. So.
Good morning, everyone. As Tom mentioned, I'm Nicole Quinn. I'm a commercial lender for Knox County. And I just wanted to say that First National Bank is proud to sponsor and support this event, as tourism is one of our largest industries in Maine. So thank you, everyone, for joining this morning, and I'll turn it over to Monique.
Thank you. Good morning. I am Monique Pierce, and I am the Knox County Regional Manager at First National Bank. And I just wanted to give a quick plug for our merchant services. We're getting ready to amp up promoting our merchant services and our payroll services. So if you or anybody that you know are interested in learning more about what we have to offer for payroll or merchant processing, reach out and we'd be happy to talk to you. And thank you all again for joining.
Thank you, Nicole and Monique and First National Bank for sponsoring this Tourism Tuesday series for us. We really appreciate it. So let's move into today's topic. If you have questions as we go along, you can just pop them in the chat or send me a message. Rebecca has said that she's willing to answer your questions on the fly if you have something that's relevant to something that she's addressing in the moment, or we can certainly wait till the end. We'll have a few minutes at the end for general questions as well. So obviously we want to get through as many of your questions as we can. So try to be succinct with your question. And you, as I said, you can pop it in the chat and I'll relay it, or when we get to the Q&A at the end, you can message me and I'll just call on you to keep some semblance of order to the proceedings today. But we're glad to have Rebecca LaPierre back with us, a familiar face from many sessions that we've held with Eaton Peabody in the past. Rebecca's an associate with Eaton Peabody's Labor and Employment Practice Group in Bangor, and she's going to go over a number of topics that are important, particularly to the tourism sector. So Rebecca, welcome. We're glad to have you with us.
Well, thank you very much. I'm very happy to be here. I've got, as Tom mentioned, a lot to cover today. We've got a lot of things going on, a lot of recent updates, a lot of recent changes in what's going on in the state and in the country and the world, and in terms of the laws that are going to affect businesses over this next tourist season in Maine. So as Tom said, please send out your questions. I'm happy to take them. I can't provide you specific legal advice as always, but I will be glad to answer general questions. And if you do need more specific legal advice, please feel free to reach out directly to me. And I'm sure that Tom can provide my email to everyone. So just a quick overview of what we're going to cover today. We're going to go over a little bit of the state mass quarantine capacity laws that have been changing and that will continue to change, hopefully, as we go into the summer. We're going to talk about testing and vaccinations for your employees. We're going to talk about the earned paid leave law that passed in Maine that may apply to some of you. The American Rescue Plan had a couple of provisions in it that will apply to employers going into the summer as well and currently. And then we are going to briefly touch on the current immigration concerns for J1 and H2B visas. Unfortunately, some of this stuff is a bit ambiguous still, so I'm not going to have a ton of great advice, but I can give you a general update. So to start off, let's talk about what's going on in the state. So Maine is currently on its Moving Maine Forward plan, and that's great news for us. So essentially what this means is that we're starting to reopen the state in a broader way. The governor's most recent order on March 5th opened up the state to Massachusetts, Connecticut, Rhode Island, Vermont, and New Hampshire. So we no longer have quarantine requirements for any of those states. Additionally, anyone who is fully vaccinated or those who have had COVID-19 within 90 days of their arrival into Maine will no longer have to quarantine when they enter the state. The target is for May 1st to open the border to all states so that there will no longer be any out-of-state quarantine requirements as of May 1, which would be great for our tourism industry, obviously. But that is pending on CDC approval, so we'll see how things kind of go over the next month and see if there's any updates on that. So there's also some updates on indoor and outdoor gatherings. The capacities are changing. So the target was for March 26th for indoor bar and tasting room reopenings. And the capacity for indoor gatherings increased to 50% and for outdoor gatherings to 75% on March 26th. As of May 24th, that's the goal date, we'll be increasing indoor gatherings to 75% capacity and outdoor gatherings to 100% capacity. Now, you should note that there were restrictions on the number of people who could be in a space. For instance, 50 people for indoor gatherings and 100 people for outdoor gatherings, or 5 people per 1,000 square feet. If your capacity is, say your 100% capacity is 50 people for indoor gatherings, you can still have that full 50 people. It's not going to lower your capacity by any means, but if your 100% capacity is 100 people, then you can now go to 75% for outdoor gatherings and 50% for indoor gatherings. But if your full capacity was the prior maximum, then you can still have that full amount. The mask mandates are still in effect. COVID-19 prevention checklists are still in effect. Social distancing is still in effect. As a lot of folks are getting vaccinated, it's really important to remember that some folks aren't eligible yet. Some folks can't get vaccinated. And a lot of people choose not to get vaccinated. So even though we've got a lot of folks getting vaccinated and we've got a lot of reopening happening, currently all of the mask and social distancing mandates are still in effect. So you are still going to have to enforce those for your business. So that's kind of a nutshell of what's going on in the state. As for the vaccination programs, it's opening up as of tomorrow. I believe 18 plus is eligible to seek appointments, and they have had appointments open for booking. So if folks are looking to get vaccinated, that is an option now for anyone over 18 as of tomorrow. So that's the state in a nutshell. Any questions about what's going on in the state for anyone before I move on to the next? I'm sorry, I'm kind of rushing through things. We got a lot of stuff to cover here today.
I think the only thing I'm going to tweak there is I think that tomorrow is actually 16 and up for the vaccines. So
I'll double check on that, but I think it was initially 18. They might have changed it to 16.
In any event, it's greatly expanded, so.
Yes, absolutely. So, all right. So for testing and vaccinations of your employees, that's something that you're going to want to keep in mind, especially if you're just initially reopening. The EEOC has permitted employers to test employees who will be coming on site for COVID-19 if you so choose. You can also require vaccines for employees who are going to be coming on site if you so choose, but there are some caveats to that. So for example, it would be considered a disability related inquiry if you were to mandate a vaccine and offer it on site and require folks to take a pre-screening test, or not a test, rather, a pre-screening check before they get their vaccine. That would be considered a disability related inquiry. So if you are going to mandate vaccines, what we are recommending is that you have folks get vaccinated off-site, not related to your company, and simply request proof of vaccination, because that will not be considered a disability related inquiry, and the EEOC has determined that that is permissible at this point. Most employers, I would say, are encouraging vaccination, not requiring it. That's a choice, a business decision that you have to make as an individual business. And if you want to do that, or if you want to implement a policy, that's something that you're going to want to talk to your attorney about, making a specific policy that will fit your business. But just generally speaking, the EEOC has determined that we can ask for proof of vaccines. We can require vaccines if we would like to, for folks who are going to be coming on site. And the thing you want to keep in mind, though, is that there will be likely both disability related exceptions and religious exceptions to that rule. So if someone says that they have a religious or a disability related reason not to get vaccinated, you will have to consider accommodations for those individuals. So that's definitely something to keep in mind. It's not going to be a broad, everyone has to get vaccinated, no questions asked. We will need to consider accommodations in those circumstances. So the next thing is earned paid leave. This is a big one. And if you aren't familiar with the earned paid leave law, I highly recommend you reach out to your attorney, you reach out to us to talk through what changes you might need to make. A lot of your businesses might be considered seasonal and therefore might be exempt from this law. That said, it's not quite so simple as just saying, well, we're only open seasonally, so we're exempt. This is a new state law. It requires all employers with more than 10 employees to provide paid leave for any reason to all employees, no matter full-time, part-time, temporary. All employees are eligible to earn and use paid leave. That said, there is an exception for seasonal businesses, but you must be recorded as seasonal by the Bureau of Unemployment. So if you are not registered as a seasonal business with the Bureau of Unemployment Compensation and haven't determined with the state that you are technically considered a seasonal business, this law is still going to apply to you. So if you haven't looked into that yet, if you haven't contacted the DOL to find out if you can be exempted as a seasonal business, now's the time to do that. If you're not exempt, you're going to want to update your policy, because this law requires not only that we provide 1 hour of paid leave for every 40 hours worked, but also has really specific use and notice requirements as well. And if you might already be offering more than 1 hour of earned paid leave or paid time off, whatever you want to call it, vacation, sick leave, you might be offering more than that already. But if it's not being made available for use and under the notice requirements of this new law, it might not quite comply, and you could still need to adjust your program for that. That said, you don't necessarily need to add additional paid leave for employees. A lot of folks have perceived this to mean that they had to add an additional 40 hours of paid leave for their employees. You don't have to add new leave, but you might have to adjust your current leave policy to comply. And again, go ahead.
I'm sorry. Yeah, if somebody is not registered with the Maine DOL as a seasonal business, but but they would qualify for that? Is a pretty quick and easy process to do that? Like, is it something that they could get switched in a matter of days or weeks, or?
So not necessarily, and that's something you'd have to contact the DOL directly about. I know we've had some folks who were able to contact the DOL and explain their circumstances and get switched over quickly, but others, have been told that they had to do it within a certain time frame or, before but I think some were told that they had to do it the year before. So I'm not 100% sure on the exact process, but it is something you're going to want to contact them and explain your circumstances if you think that you should be a business that would be eligible to be qualified as seasonal.
Super.
And depending on how the DOL decides to deal with that, you may or may not be successful in getting that determination for this year.
Sure. Thank you.
No problem. All right. So the American Rescue Plan. Some of you, if you were open throughout the year or if you were open last year, you might have been familiar with the FFCRA, which provided paid sick leave and paid family leave for folks that needed to be out of work due to COVID-19 related reasons, such as their children being out of school or if they got sick or they needed to get tested. That program, the FFCRA program, ended and was not renewed for a new year. However, the CARES Act and the American Rescue Plan both sort of adapted that program and added a voluntary program that employers can use. So the current state of affairs in terms of paid sick leave relating to COVID-19 or paid family leave relating to COVID-19 is under the American Rescue Plan. It is completely voluntary. So employers have an option to provide paid sick leave for all of the same reasons that the FFCRA was available, as well as for getting vaccinated, or if the employer requires quarantine. So it's expanded the reasons for leave that can be paid now, but it is voluntary. You do not have to provide paid sick leave for these employees. That said, if you choose to provide paid sick leave under the American Rescue Plan, you will be eligible for a tax credit. And the best thing about this particular version of this law is that it actually also provides a tax credit for municipalities as well. So if we have any towns on the online today, municipalities previously were not eligible for a tax credit, they now are, if they choose to provide this paid leave. If you're a private employer, you were always eligible for the tax credits, but now there are more reasons for the tax credit, and it sort of renewed the availability of leave. So someone who already took 2 weeks of paid sick leave can now have another 2 weeks of paid sick leave for the eligible reasons. And the family medical leave has been expanded to be a total of 12 weeks rather than 10 weeks with 2 weeks unpaid. So it's changed things up a little bit. Like I said, added some new reasons for being eligible for paid sick leave or for family medical leave. So currently, previously it was if you were under quarantine with a state order or if you were actually sick or getting tested. Now you can also get paid sick leave or provide paid sick leave for a tax credit if someone is obtaining a COVID-19 vaccine, if they're recovering from an injury, disability, illness, or condition related to getting that vaccine. So say someone's had an allergic reaction, or say they're just having some bad side effects and they need to take a day off. If you provide paid sick leave for that, you can get a tax credit for providing that paid sick leave. As well as, if someone's getting tested or waiting for a diagnosis, or if the employer has requested that they stay under quarantine or they stay home, you can provide paid sick leave for that and still get a tax credit for that. So that's kind of the update on that in a nutshell. It's got a lot of layers to it. So again, if you think that you're not sure how you want to apply that, or if you want to offer those paid leave options right now, or if you can, operate while offering those paid leave options, it is voluntary. You don't have to. But again, you might want to talk to your attorney or to your HR folks and figure out what the best course is for your business. So I know that we had some requests to discuss the H-2B and J visa programs for this summer. I'm sure a lot of your businesses do rely on temporary workers and exchange employees, students who come over for the season. Unfortunately, I don't have a super clear answer about what's going on with this. The presidential proclamation that had temporarily suspended entry of those types of visas did expire on March 31st. The Biden administration did not extend that presidential proclamation, so it has fully expired, and those visa programs are now available. What the State Department has said is that visa applicants who have not yet been interviewed or scheduled for an interview will have their applications prioritized and processed in accordance with the existing phased resumption of visa services guidance, which basically just says they're getting things back in action. It's probably going to be a bit slow as the consulates and the embassies start to reopen and start to have routine visa services become available again. As USCIS gets back in action in the States, it's definitely going to be a slow process. Immigration generally has been slow lately. I think that it seems as though they might be, understaffed and maybe not, since they haven't been doing all of the visa services, a lot of backlog and getting caught up. So if you are counting on summer employees who are either H-2B visa recipients or J visa recipients, you might need to have a little patience in terms of getting them here and getting everything ready to go. They've also stated that visa applicants who were previously refused a visa due to the restrictions of the presidential proclamation may reapply by submitting a new application and a new fee. So if you have an employee or you had applied for a visa for an employee and that was refused, you can reapply now. It's worth noting that US citizens, services for US citizens are being prioritized right now. That said, I believe they are making these visas a priority, sort of a second priority behind the services for US citizens. But again, keep in mind, they are very backlogged. Things are moving a little slow. There's a lot of delays in terms of the immigration world right now. So you're going to have a little patience. And I know that recently there have been some, pushes by state businesses and the state government and the senators to try and move these things forward and to try and make it more of a priority because a lot of our tourist industry does depend on these employees. So hopefully we'll see some movement there. But for now, it's still going to be a little slow going, just to keep that in mind. Let's see. The other thing to note is that if you have other immigrants coming to work or for any or non-immigrants coming to work for you, there are national interest exceptions for certain types of visas and for certain locations. You're also going to want to keep in mind that certain countries are still under a lot more restrictions depending on what the status of COVID-19 is in those countries and how the infection rates are looking, depending on if those countries are open for travel or not. For instance, I believe that Romania, which is generally a large source of both J1 visas and H-2B visas, is essentially shuttered right now due to large numbers of COVID-19. So if you have folks who are typically coming from that area, it might be a little harder to get them over here right now. Let's see. So that was sort of the general overview of the different topics. And I know I rushed through some of it because I know that we probably have questions and it's, a lot to go over in detail. So I guess what I'd like to say is, are there, which topics are most relevant to our audience today? What is it that you would like more detailed information on? And I'd be happy to kind of dive in a little more detail on any of those topics.
That's great. Well, let me thank you for that great overview. I do have one question that I'll share with you in a minute from one of our participants, but just generally to everybody on here, if you have a question, you can either type your question in the chat or just let me know that you have a question and I will call on you in order to ask your question of Rebecca, so that we can make the most of this and kind of keep this somewhat organized here. So the one question we had in the chat so far was about outdoor gatherings like graduations and concerts. And I think in the past there may have been a people count, but but now it's really more about a percentage of the capacity of the venue. Is that accurate? So.
Yeah, that's right. It's going to depend though on what your capacity is. So I realize it's a little confusing, but essentially right now, as of March 26th, the capacity limit for indoor gatherings is at 50% of total capacity and 75% of total capacity for outdoor gatherings. That said, the prior capacity limits that were a head count can still apply if your capacity, so say 50% of your capacity exceeds the prior head count, you could still use the prior head count as your capacity, because essentially they're not trying to make it so that you can have less folks. So say for example, if the capacity was 50 people and now and your full capacity was 50 people and now they're saying it's 50%, you don't have to reduce it to 25 people because it's at 50%. You can still use that 50 people maximum that was previously in place. If, for instance, though, if your capacity is 200 people and it's now up to 50% and you had been limited to 50 people total, now you could have the full 50% of 100 people to be in your indoor gathering. So it's increased to it's changed to a percentage based inquiry, but at the same time, if the previous head counts were beyond this capacity for you, you can still use those previous head counts.
Mm-hmm. Great. I just wanted to loop back on something you had mentioned earlier about having vaccines for employees and asking them to provide documentation of that, which sort of made me think about sort of how lodging properties in particular have been instructed to manage requesting proof of compliance from visitors, but you can't really ask to see evidence of quarantining or that kind of thing. You can only have people sign a form that they did just for HIPAA regulations. So there is a difference between what you can ask of an employee and what you could ask of a customer. Is that right?
Yes, there is a difference between employees and customers. So customers, when it's the public, it's considered public accommodations. And there are different requirements of what you can and can't ask. Whereas with an employee, you can ask more with an employee, but you need to be careful because when you have disability related inquiries, you could violate the ADA. Just on that note, currently there are still checklists in place for the state for lodging or for all industries. So if you are, reopening, be sure to check your industry specific checklist. And the lodging checklist does still include the certificate of compliance form for check-in for anyone who's not a resident of Maine or an exempted state. As I said, the goal right now is for May 1st to be the date that there's no longer a quarantine requirement for outside visitors, at which case that certificate of compliance should be moot because there wouldn't be anybody who wasn't exempted from traveling. But currently there is still that certificate of compliance that you do need to have folks fill out when they check in if they're not a resident of Maine or an exempted state. That will verify their testing and quarantine requirements. But yes, that's correct. When it comes to public accommodations, we're limited on what we can ask in terms of follow-up questions. So if someone says, I have a disability or I have a reason I can't wear a mask, you don't have as much option in terms of following up on questions. That said, in this particular circumstance, the the general understanding is that COVID-19 is considered a direct threat to the public health. So we have a little bit of leeway in terms of how we deal with those situations that we wouldn't have under normal circumstances. So under normal circumstances, if someone says, I can't do this and I need an accommodation, you basically just have to figure out an accommodation for them. But under these circumstances, the accommodation does not have to be let them in without a mask. In fact, you cannot, based on the governor's current orders, allow them to come in without a mask. So you do have to be enforcing those mask orders. And that said, if somebody says, I have a disability and I can't wear a mask, or I have a religious reason that I can't wear a mask, you might need to provide them services, by bringing something to them outside the building, or finding some sort of an alternative. But we don't have to permit the accommodation of just straight up not using a mask, just due to the direct threat of COVID-19 as a public health issue.
Great. Next, I've had a question that references specific bills in the Maine legislature, and I've looked them up because I didn't know exactly what each one represents, but maybe you can comment on these individually. The first one is LD 61, which is about including grandparents under Maine's family medical leave laws. So are you familiar with that, or where that stands, or how that might impact things?
So I'm not familiar, but I'm looking at it and I can tell you if it's gone anywhere so far. It looks like there was a public hearing on February 3rd for it. So I'm not sure where that's going. I wouldn't be surprised if we do hear more about that coming up. It's been on March 8th, it looks like there was a vote that it ought to pass by the majority of the committee. So it's probably on track to move forward. But hard to say at this point, because it's still being decided on. And that would just be, it looks like it's just for the state family medical leave laws. So if you are, depending on your number of employees, if you're concerned about that, if you're eligible for family medical leave under the federal law, if your employees are eligible and you're a covered entity, the federal law is actually more beneficial to employees, so that's what's going to apply. So if this is a concern of yours, just make sure that you are checking to see if you even would need to be covered by the state family medical leave law, because if you're covered by federal family medical leave, this isn't going to really apply to you. But if you don't have enough employees to be covered by federal law and you are covered by the state family medical leave law, then you're going to want to keep an eye on this. And that is something that will likely have, I mean, it looks like it's moving forward in a positive way, so it's very likely that this could be passed, that this could become law, and it would just likely add grandparents to the list of covered family members that would be eligible to take family leave to care for a grandparent. Or no, it's for a grandparent to care for their grandchildren. So that would basically essentially make it so that grandparents who care for their grandchildren, if their grandchild has a serious health condition, they could take family medical leave to care for that child. Who so that's that one. But like I said, it's hard to say until it's actually gone through the full process to know if it's going to become law or not.
Sure. There's the other, and next one they asked about was LD 447, which is also about family medical leave. Just a little different aspect of that.
Paid parental leave for all parents employed by companies offering paid parental leave. That looks like it hasn't actually had a vote yet. So I can't really comment on where that one's going. It doesn't look like, it says it was referred to the Committee on Labor and Housing on February 11th, and the public hearing was on Monday, March 1st, but it doesn't look like there's been a vote on it. So I'm not sure what direction that's going in right now.
Right. Another one that I've heard some about, and I think is probably concerning to a lot of Maine employers, is LD 553, which is an act to end at-will employment in Maine. So maybe you could speak to that for a minute, because I think that would be pretty significant.
Yes, that one I believe just had its public hearing like a week or so ago. It was very recent. So that there's really, I really don't have any comment on what direction that's going in. It would have a great impact on Maine employers. It would have a great impact on Maine employees as well, who want the option to be able to quit their job. So it's definitely one to keep an eye on. It's, I would say, I really, I can't, project what the likelihood is or isn't. I don't know what the public hearing testimony consisted of, but it looks like there was a good turnout. There's almost 80 individuals who testified. It looks like quite a few, a mix of both employers and employees likely. It looks like there's plenty of individuals as well as a number of businesses that were represented. So again, hard to say where that's going to go, depending on sort of how that public hearing went and what the reaction was. Excuse me, but I believe you're right. I think a lot of Maine businesses probably are pretty concerned about this bill coming into play. So I suspect that the public hearing represented those concerns. And
Can you just maybe touch briefly on what the nuts and bolts of what that would mean for a business? I mean, I think for one example, I mean, you would lose the ability to terminate an employee for without cause, basically, right? So, and there would be, I think the bill spells out a 3-step sort of warning policy before you. So if if you had what you would consider to be an offense that would be something you would terminate someone over, that you would in effect lose the ability to do that without giving them 3 warnings, as I understand it. Is that your understanding
yeah.
of how that, one aspect of how that works?
Yeah, so at-will employment, essentially, as you all know, means that the employer or the employee can terminate employment at any time for any reason or for no reason. This bill would make it so that the for no reason part is no longer allowed. You would only be able to terminate employees for cause, meaning that there was a reasonable basis based on the factors and circumstances, such as employee conduct or a violation of employer policies, for terminating that employment. Generally speaking, I think that's kind of how things tend to go anyhow. Very rarely does somebody just decide to terminate an employee for no reason. And I think the concern from the employee side is generally that folks don't want to lose their job for no reason or for a pretextual reason, because that's a misconstruction of what the at-will employment means. So folks think that they're going to get terminated for they think they're going to be terminated for not doing anything wrong or for a discriminatory reason, which would still be illegal. So this law essentially says that yes, you should have a progressive discipline policy prior to termination. So you should go through the steps of trying to give them a chance to make it better before you terminate them. And then if you're going to terminate them, it would have to be for cause, following the progressive discipline policy. Generally speaking, we actually advise against progressive discipline policies, because it can be hard to follow those when it comes to equal treatment of all employees, because not every infraction is the same. So sometimes, you know, you have an employee who does something really terrible and you don't want to go through the progressive discipline. You just want to be able to terminate them for that major infraction. Whereas, you know, a smaller infraction, it's not so bad to go through a process of a written warning and an oral warning prior to actual discipline. Or termination. So this law does require a progressive discipline policy. It requires that you have a uh, a reason, a cause for termination of employment. It essentially makes it so that people are contracted to normally the way this works is that if you have a contract for employment where you actually guarantee employment for a period of time, then there would be a provision in that contract that specifies what causes of action would allow you to terminate the employee. And this law kind of makes that across the board for all employees. And that is definitely something that is going to be difficult for a lot of employers to implement. So I would keep an eye on this. I would be surprised if there wasn't a pretty significant backlash from employers at the at the notion of this law being passed, because it could be pretty problematic for employers to implement. And it's a little bit, it's like I said, though, it's early right now. It's hard to say. We've just had the public hearing on it. So we'll have to kind of see where the committee goes with it, and if they move it forward in a positive way, or if they say that it ought not to pass based on that public commentary.
Right. So the last one that this person brought up was LD 225, I think it was, which is relating to requirement to pay out accrued vacation time upon termination of employment. So,
Yep. So let's see.
which employers currently can have a variety of policies on right now, but that would
Yeah.
not.
So
would change that.
the current law is that if you don't have, if your policy is silent, or if you don't specifically say that you're not going to pay out vacation, it would be paid out at termination. This would essentially take away that option. And at the end of employment, all accrued vacation would be paid to the employee. Now, this is going to get a little complicated because the new earned paid leave law ties whether or not you pay out earned paid leave to whether or not you pay out vacation at termination. So if it becomes a law that you are required to pay out vacation, you would also be required to pay out earned paid leave at the time of termination. So that could get a little tricky. And on top of it, but I'll note it doesn't seem to address sick leave. So it would just be, I think, vacation that would be affected, which would then in turn affect earned paid leave. But currently there is no law that requires you to pay out sick leave. I would say most of the employers I work with do pay out vacation pay at the end of employment anyhow. So I don't know if this would be as impactful in terms of whether or not folks pay out vacation pay at the time of termination. But for those who do have a policy that says that they will not pay out earned paid leave, or will not pay out vacation pay at the end of employment, this would affect those employers. Currently, like you said, employers are allowed to have a policy that specifically says that they will not pay out vacation at the end of employment. This was tabled on March 17th. And there is no report from the committee. There was a public hearing on February 10th. It looks like there were about 16 folks who commented on it. So it's currently, I think it's currently on hold, essentially. The work session, like I said, was tabled, so it's not being voted on at this moment.
Right, great, okay. All right, I'll put out one more call for questions. I don't see any others in the chat right now, but we have a few minutes left if there are other questions, but if not, we can certainly wrap up a little early. So Rebecca, anything else that you wanted to address in closing, or
The only thing I would say is I've had a lot of clients who are really eager to kind of jump ahead and get ahead of the game and make a plan for our future where everything is back to normal. I would say keep being patient. I think that's the number one thing right now, is to just maintain a little patience for a little bit longer. I know a lot of folks, they're like, oh, well, I got vaccinated, so everyone must be vaccinated, but that's not the case. A lot of folks haven't been eligible or just are becoming eligible tomorrow. And you were right, Tom, it is 16 plus. So my mistake, and thanks for catching that. So tomorrow, as of tomorrow, 16 plus is eligible for vaccines. That doesn't mean everyone's going to get an appointment right away. There's a lot of people who are still very hesitant about getting a vaccine. So it's easy to get overexcited and to want to roll out a plan for the dream world where everybody is immunized and there's no concerns anymore. But you got to remember that we're still in the slow progress. We're still getting there. Things are getting better. Hopefully that May 1st opening of the state will actually happen. It seems to be that the rollout is moving along quickly. So hopefully, fingers crossed, that means good things for our summer. But, I would say take it one day at a time. Try not to get ahead of yourself. Continue maintaining all the social distancing and the mask requirements that are the state law right now. And just keep a positive outlook that, hopefully within a few months we'll be closer to getting back to normal and being able to update those policies and change things. The other thing is, if you do still have folks working from home, make sure that you are updating your telework policies. If that's something that you're still dealing with. If if you're a business that's public facing and everyone's coming in and out, that's obviously not gonna apply to you.
Right. Super. Well, Rebecca LaPierre from Eaton Peabody, thank you very much for sharing all this great information with us. We appreciate it. Good to see you again, and I'm sure we'll have other sessions with you down the road also. So today was our fourth and final Tourism Tuesday session, and we hope that you've all found these to be helpful. And we'll be posting this recording on our YouTube channel if you want to go back and review anything that Rebecca said, or share it with somebody who wasn't able to be with us today. That would be great. Thanks again to First National Bank for being our sponsor of our Tourism Tuesday series. And feel free to reach out to the Chamber if there's anything else we can do to help you or support you in your business or your organization. So good to see everybody, and thank you for being with us. Have a great day.